everyone, welcome to our channel Knowledge Hub. Friends, subscribe to our channel and click the bell icon for the latest update. आज हम साइबर सिक्योरिटी की क्लास करने वाले हैं, जो कि क्लास नंबर आपका 7 है। ऑलरेडी हमने 6 क्लासेस कर लिया है, जिसमें हमने यूनिट 1, यूनिट 2, यूनिट 3 ऑलरेडी कंप्लीट कर लिया है। एंड आज हम जो स्टार्ट करेंगे वो यूनिट 4 करेंगे। एंड होपफुली इन दिस क्लास विल एंड अप विद यूनिट 4 एज वेल। एंड फर्स्ट ऑफ ऑल इट्स अ ह्यूज रिक्वेस्ट कि अगर आप हमारे चैनल फर्स्ट टाइम देख रहे हो या अभी तक आपने हमारे चैनल को सब्सक्राइब नहीं किया है, प्लीज़ गो थ्रू विद द सब्सक्राइब बटन सो दैट यू विल गेट ऑल द इन्फॉर्मेशन रिगार्डिंग दिस एंड यू विल एंजॉय द वीडियो एज वेल, एंड यू कैन यूटिलाइज ऑल दीज वीडियो फॉर योर examination as well, and even though for your knowledge as well. Let's go ahead with the unit 1 and unit 4, that is the security policies. We have to gone through with the security policies here in the unit 4, and that is the last unit of the cyber security according to the syllabus, and according to your convenience. If you want to discuss many of the topics related to the cyber security, you can just comment it on and I will be providing you those also as well. In the regard of it, that the first topic we have to discuss here is your security policies here. And in terms of the security policies, first of all, you have to understood what is security policy. Then after that we'll discuss about the security policies elements here. For the security policies, what you have to get to know is that security policy is a high level statement that describing the security goals, priorities and the management intentions with the regard to the information system security, and as well as the way to achieve these goals is. And in the terms of the security policy, that is written in one or more document here. Now we'll talk about the security policy elements here. The elements we have is, that is, first is your design, second is implement. First you have to design, then you have to implement here, and then you have to publish, enforce, monitor compliances, evaluate, and then after that we have review, and then amend and update here. Then after that what you have to do is, in terms of these, what you had be cleared it all about that security policy and the security policy elements as well. Now we'll discuss about the types of security policies, कि कितने types के security policies होते हैं. And that what we have is, the first the types of the security policies we have is that the computer oriented security policy first, second is your human oriented security policy, third is individual security policies, the fourth is the comprehensive security policies, and the fifth is your modular security policies. With regard of the types of security policies, the first we have is the computer oriented security policies. Here in regard of it, that is in the computer oriented security policies, that the information security policies that implement the access control, discretionary access control or the mandatory access control here in regard of it, and that operating systems, networks, and as well as application as well. Now we'll go ahead with the human here. Here with second one, that is your human oriented security policies here. In regard of it, that is the scope is that the department, organization, and applied by the ISA user in the human oriented security policies as well. And with regard of it, if I'm talking about for the next one, that is the individual security policies. In the individual security policies, what it stands for, that the application or a system, that example the male female policies, and that use policies, what they uses policies. The first is your pros and cons. प्रोज एंड कॉन्स क्या है? प्रोज है दैट इफेक्टिव फॉर आइसोलेटेड सिस्टम एंड ऑटोनोमस एप्लीकेशन, एंड कॉन्स है दैट इज हाई complexity, fragmented IS security management as well. The next we have is your comprehensive security policy. In the comprehensive security policy, that is one document addressing all the application processes and the systems. The cons for this is that big volumes and not easy to use. Pros is that contains the high level security guideline as well. The next we have is the modular security policies. In the modular security policies, that comprehensive document with a multiple annex containing the specific, like example, a per application or a system policy, and that can be hypertext form as well. Now we'll discuss about the basics rules in the that is shaping a policy here. Before that, we have to understand who is involved in security policies here. In regard of it, that the security experts are involved in it because they design, review and update the policy. And the second is the system and the network administrator. Their role is to implement the security control guidelines. The third is your management, that is the set security goals and provides the resources. The fourth is the user itself, that follow the security procedures, and the fifth is your auditors, that is monitoring the compliances. So these were who involved in the security policies here. And after that, the next question they can ask you about why policies should be developed, क्यों policies developed होना ज़रूरी है या करना ज़रूरी है. In regard of it, that the management of the IT security या management हो IT security के लिए इसलिए, and all about the management of the risk and the balancing with the availability of the services, even though having a performed a risk analysis and need a security plan includes various controls as technical, operational and management to mitigate and manage risk as well. And with regard of it, that provides a comprehensive framework for the selections and implementation of the security measures as well. And the next is you to provide effective communication among the different stakeholders. Management of resource like people, skills, money and time conveys the importance of security to all the members of the organization. The next is used to help to create a security culture that is assured beliefs and values concerning security. The next is to legal obligations, that is to help promote a trust relationship between the organization and the business partners or client. And the quality information security programs begins and ends with policy. And although the information security policies are the least expensive means of control to execute, and they are often the most difficult to implement as well. The next we have is to policy control cost only the time, the effort and the management team spends to create, approve and communicate them, that employees spend integrate their policies into their daily activities as well. And even though cost of hiring a consultant is a minimum compared to the technical control as well. Now we'll discuss about the basic rules in the shaping a policy here. And the basic rules in the shaping a policy is the first we have is to policy should never conflict with the law. The second is that the policy must be able to stand up in court if challenged. And the third is that policy must be properly supported and administered as well. Now we'll discuss about the major consideration with WW security policies here, that after that the policies should be never conflict with laws, policies must be able to stand up in the court and if challenged, and the policy must be properly supported and administered as well. In the regard of it, if I'm talking about here, what are the major considerations with WWW security policies here, that before email security policies we have to start with it. And for the that if you are a webmaster, system administrator or are otherwise that involved with the administrator of a network, the single most important steps you can take to increase your site's security is to create a written security policies. The security policy should summarily lay out your organization's policy with regard to like who is allowed to use the system, when they are allowed to use it. Okay, these were the things. And even though you can see to it like in the form of the frames here, and that is what they are allowed to do, that is different groups or may be granted different levels of access, procedures of granting the access to the system, procedure for revoking the access, example when an employee leaves, and what constitute acceptable use of the system, remote and the local login method, and system monitoring procedures as well, and the protocols for responding to suspected security breaches as well. These policies need not be anything fancy, if you need only in a summary of how the information system works, reflecting your organization technological and the political realities. There are several benefits to have a written security policies. The first we have is that you yourself will understand what is and is not permitted on the system. If you don't have to clear picture of what is permitted, and then you can never be sure when a violations has occurred. The second is that the others in your organization will understand what the security policy is, and the written policy raises the level of the security considerations, who provide a focal point for the discussion as well. The third, we can say that the security policy serves as a requirement document against which the technical solutions can be judged, and this helps the guard against the first that ask questions later, like syndrome here. The fourth is that the policy may help bolster your legal case should you were used to prosecute for a security violation as well. The next we have is email security policies here. In regard of it, there are the basics email security policies, and they should be followed by everyone using email. The first is that never read unsolicited email, an email from an unknown sender in regard of it, because the act of opening and reading such emails can expose your computer and network to the outside threat as well. The second we have is that never click on attachment from the unknown sender. For this, because the viruses are the other malicious software lurk into the attachment that often promise to be in the picture or a game form. The third one we have is never respond to a financial or the other offers, no matter how legitimate they appears to be. Like in the case of this here, that the legitimate company do not request confidential information such as credit and card and social security number by the email. Any that sweepstakes or the other offers that looks too good to be true should be ignored. The next we have is that never share your email account password. Here, with regard of it, as with the past, any passwords, email security information must be kept absolutely confidential. And the next we have is never forward an unsolicited email, where you should not be reading it and must less forwarding it. The next we have is never use the business email essence for the personal mail. And here, in regard of it, by restricting the business accounts to the business use, you take a larger steps toward the reducing the risk of email security problem as well. Now before next we have an heading here, as is that is you can see here, that is information security standard. In terms of information security standard, first of all you have to understood about the guideline for the email security policies. Then after that we'll discuss about the information security standards as well. Here in the guidelines for the email security policies, that what we have is that email is an electronic equivalent for a postcard. Because of this, it requires a specially policy considerations from achieving to a content guideline. Organization have a lot of to consider when writing email policies. The first policies, the guidelines we have, that policies should be written to promote the responsible use of the email that supports the organization's goals and the business requirement. The second is some of the items that should be included in the policy concern courtesy, contents, and the general usage and the compliances with the policy as well. The third we have is the policies describing the administration of the email, discuss the actions the organization will follow in the management of the email system as well. The fourth is your administrative policies should establish the right to scan message and passing through the email system. This scanning can be for the virus or the content as well. The next is that regardless of the scanning type, there should be a policy in place that says the organization is doing this. The next is that email policies might include mechanism to limit the size of the message to prevent the overloading of the servers and the network bandwidth. The next is to mitigate the other problems. The organization might want to include a policy that allows them to use the proxies, gateways, and the other means to aid the transmissions of the message. These policies should not imply that the messages are being filtered or retained. Next is that if the email messages are archived, there should be a policy that outlines the basics for how this will work, and this policy also should define the retention period and the potential exceptions into the policy here. Now with regard of it, in the terms of it, the next we have the policy guideline is in the case of the policies that the policies for sending the confidential communication include like provision for the encrypting the data and before the transmission and the signing them with a digital signature. The encryption policies are really not the scope of the email policies. Thus, the policy statement should refer to the user to the organization encryption policy for the information as well. Now, the next one we have is related to the information security standard. But before that, there is PMG, that is Policy Management Group. That what you have to understood about it, where that will flows towards it, and that I will be just telling you, okay, so that you will get the information regarding to PMG here, and so that you can also gone through with that, and you can just also be answerable if they had asked you in the examination as well. So with regard of it here, so in regard of the PMG here, that the first step for the PMG is that that decision is made through the legislature recognized need of the due date, and that is a review to the already existing policy need to be amended. After that, it will give that it is a major or a minor amendments. If it is major amendments, पहले तो देखा जाता कि ये major amendments है कि minor amendments है. In regard of it, अगर वो major amendments है, what to do is, then what we have to do is, if it is major amendments, then it will go goes to that the responsibilities officers drafts amendments using that templates, ensuring that the relevant areas of the university are consulted, and then it goes to the policy sponsors reviews the amendments as well, and the next that it will goes to the policy sent for the general consultations using the agreed and approval outlets as well outlets. In the general consultations using the agreed and approved outlets, that it goes to the policy receives to the feedback and shows the policy needs redrafting, and then it goes to the policy is redrafted incorporating the feedback as well. When the policy is sent for the general consultation using the agreed and approved outlets, then it goes to the policies receives no feedback or a feedback which does not necessitate redrafting as well. It goes to the policies sent to PMG, then after that policies went sent to approving body or the individual, and policies sponsors is notified and policy is communicated and implemented as well. And then it goes further, that is policy reviews every X years as per the policy framework or as necessary as well. And this is a policy review process here, and if it is minor amendment, then it goes to the reviewed by the responsible officer functional areas and the PMG as appropriate, and after that it will goes to the policy revised, and then after that it goes to the approved the policy management group, and then it will goes to the policy since that is the sponsor notified policies publishing as well. Now with regard of it, if I'm talking about here, and in the case that what do you think by the corporate policies, what you have to understood in a very clear manner in the reference to the corporate policies, that corporate policy is also called as a company policy, and usually documented set of the broad guidelines formulated after analysis of the internal and the external factor that can affect the firm objectives and operations and plans as well, and that is formulated by the firm or board of the director. Corporate policies lays down to the firm responses to known and unknowable situations and circumstances. It also determines the formulations and implementations of strategy and directs and restricts the plan, decision and actions of the firm officers in achievement of its objective, even though it also forms the basics for the measuring performances and ensuring the accountability at all the levels of the company as well. Now we'll discuss about the information security standard, that what we have to. Before starting with the information security standards, we have is ISO 27001, ISO 27002, ISO 27003, ISO 27004, ISO 27005, ISO 27006, and ISO 27007 here. In regard of it, the ISO 27000 series of the standards have been especially reserved by the ISO for the information security matters, and this is of course that aligns with the number of the other topics, that is including the ISO 9000 quality management, and that is ISO 14000, that is environmental management as well. In regard of it, the 27000 series will be populated with a range of the individual standard and documentation, and the following matrices reflects the current and known positions for the major operational standards in the series, and for that sake we'll start with ISO 27001 here. In regard of it here, that this is the specifications for an information security management system as an ISMS, which replaced the old BS 7799 standard. And ISMS is a framework and the policies of the procedures that includes all the legal, physical and technical controls involving in an organization information risk management procedure as well, and that is the processes as well. The second is your ISO 27002, and with reference to the ISO 27001 here, according to its documentation, the ISO 27001 was developed to provide a model for the establishing, implementing, operating monitors, reviewing, maintaining and improving an information security management system as well. In regard of it here, that ISO 27001 uses a top-down risk-based approach and is technology neutral, and this specification defines the 6 parts of planning process. The first we have here is that define a security policies, define the scope of the ISMS, conduct a risk assessment, manage identified risk, and select the control objectives and the control to be implemented here. And then we have a prepare a statement of the applicability. In ISO 27001 here, in regard of it, that what it is, that the specification detail of the documentation management and responsibility, internal audits, continual improvement and the corrective and implementive actions that the standards required and cooperative among all the actions of all of an organization. The 27001 standard does not mandate a specific information security control, but it provides a checklist of the control and should be considered in the complying the code of the practices like ISO slash IEC, and that considered in the complying the code, and that is 27002 and 2005. The second standard describes a comprehensive set of the information security control objective and the set of the generally accepted good practice security control as well. Let's go ahead with another one, and that is your ISO 27002 here. In regard of it, if I'm talking about that this is the 27000 series standard number. What was the originally the ISO that is your 17799 that standard, and which itself was formerly known as BS 7799 one here. In regard of it, ISO 27002 contains 12 main sections. The first is your risk management, the second is security policy, third is organization and information security, the fourth is the asset management, fifth is human resource security, sixth is physical and environmental security, seventh is communication and operational management, eighth is access control, the ninth is the information system acquisitions, the development and maintenance, 10th the information security incident management, 11th is that the business continuity management, and the 12th is that is compliances as well. In this regard of it, that the organization are required to apply these controls appropriately in the line with their specific risk, and the third parties that accredited certification is recommended for ISO 27001 conformance here. The other standard being developed in the ISO 27000 families are, and that is ISO 27003. In the terms of it here, that this will be the official number of the new standard intended to the offers guidelines for the implementations of an ISMS management system that it is. And with regard of ISO 27004 here, this is the standard that covers the information security system management, measurement and matrices, and including the suggested ISO 27002 aligned control here. Then next we have is your ISO 27005. This is that is the methodology independent ISO standard for the information security risk management as well. The next we have is your 27000 ISO 27006 here. This standard provides the guideline for the accreditation of the organization offering the ISMS certification as well. The next we have ISO 27007 here. This standard provides the guideline for ISMS auditing as well. Now we'll go on ahead with another one, and that is that what do you understand by the information security management, that is the system ISO X that is 27001. With regard of it, before going through with that, we have to know about that the information security management system, that is ISO IEC 27001. In regard of it, that ISMS that provides a framework to establish the implement, operate and monitor the review to maintain and improve the information security within an organization, and even though that implement the effective information security that really meets the business requirement, and that manage risk to suit the business activity, manage incidents handling activities, build a security culture, conform to the requirements of the standard. With the ISMS, we are not intending to make the systems hacker proof, but developed a mechanism which can to a large extent, and that is anticipate a potential problem as well. And in regard of it, we can say that to prepare through proactive measures, that is protect against concentrations damage, ensures the recovery and the restorations, and failure is not when you fall down but when you fail to get up, that is. And the next is the standard comes in the two parts, that is ISO IEC 27002 1 till 2005, and the second is your ISO IEC 27002 or 2007 here. For the ISO IEC 27001 2005, in a standard of specifications for an information security management system, ISMS, which instructs you how to apply ISO IEC 27002 and how to build, operate, maintain and improve the ISMS here. In regard of ISO IEC 27002 2007 is a standard code of practice and can be regarded as a comprehensive catalogs of good security things to do here. and that we'll discuss here. Now in terms of the cyber's law, and in the terms of the cyber law, what we'll discuss is the cyber laws. And the cyber laws encompasses law relations, and further encompasses a law relating to. First we'll discuss about the cyber laws, and in reference to the cyber law, that the cyber law is a law governing the cyberspace. The cyberspace is a very wide term to include the computers, networks, software, data storage devices such as hard disk, USB disk, etc., the internet, websites, email, and even electronic devices such as cell phones, ATMs, and ATM machines, and etc. Law encompasses the rules of conduct. That is, the first we have is that have been approved by the government, and the second is that which are in the force of over a certain territory. The third we have is which must be obeyed by all the persons on that territory. Violations of these rules could lead to the government actions such as imprisonment or fine, or an order to pay the compensation as well. In the terms of that is the cyber law encompasses the law relating to. The first we have is the cyber crimes, the second is electronic and digital signature, the third is your intellectual property, and the fourth is the data protections and privacy. For the cyber crimes here, the first one, in the cyber crimes are unlawful act where the computer is used either as a tool or as a target, or both. That enormous growth in electronic commerce, e-commerce, and online share trading had led to the phenomenal that spurt in the incidents of the cyber crimes. And for the second one, that is your electronic and digital signature. Here the electronic signatures are used to authenticate the electronic records. Digital signatures are of one of the type of the electronic signature. Digital signature satisfies three major legal requirements, that is the sign of authentications, message authentication, and the message integrity. And with regard of it, the technology and the efficiency of the digital signature makes them more trustworthy and than the hands written signature as well. And for this third one, we have intellectual property here. In the intellectual property is refers to as the creations of the human mind, that is example a story, a song, or a painting, or a design, etc. The fact of the intellectual property that relate to a cyberspace are covered by the cyber law. And here that copyright laws in the relations to the computer software, computer's resource code, websites, and the cell phones content, etc. Software and the source code license. Trademark law with the relation to the domain names, that meta tags and mirroring, framing and linking, etc. And semiconductors law, which relates to the protections of the semiconductors, integrated circuits, designs, and layout. And even though the patent law in relation to the computer hardware as well as in the software as well. In regard of it, the next we have is the data protection and privacy. Here the data protection and the privacy law that aim to achieve the fairness balance between the privacy rights and the individual and the interest of the data controller, and that such as banks, hospitals, email services providers, etc. These laws seeks to address to the challenge to the privacy caused by the collecting, storing, and transmitting the data using new technologies. And here now we'll discuss about the sum of the scope and objectives, as well as first we'll discuss about what are the IT Act 2000 provisions here. First we'll have to understood about the IT Act 2000 provisions, that you can you just write it down while you are going to make a notes here. And for that sake, IT Act 2000 provision, that first is that it extends to the whole of India. Electronic contracts with legally valid and legal recognitions of the digital signature, security procedures for the electronic records and the digital signature as well, and appointment of the controller and the certifying the authority to license and regulate the working of the certifying authorities. The certifying authorities to get the license from the controller to issue digital signature certificates, and various types of the computer crimes defined, and stringent penalties provided under the Act. Appointment of the adjudicating officers for holding the inquiries under the Act, and establishing of the cyber regulatory appellate and tribunal under the Act. appeal from the order of adjudicating officers to the cyber appellate tribunal and not to any civil court as well. That appeal from the order of the cyber appellate tribunal to the High Court, an act to apply for the offense and the contraventions committed outside India, and that network services provider not to be liable in certain cases, and that the power of the police officers and of other officers to enter into any public place and search and arrest without warrant, and the Constitution of Cyber Regulations Advisory Committee to advise the central government and the controller as well. Now in regard of it, we'll go ahead here. We'll go ahead with another one, that is the major components of the ISMS. Here this is your this is a plan to do, and then to check and check to act. In regard of it, this is to establish the ISMS here, where planning has been done, and after that when to do that is implement and operate the ISMS, then check that to monitor and review the ISMS, and that act that is to maintain and implement ISMS here. In regard of it, if I'm talking about here, when that the organization should define the ISMS scope and policy, that organization should identify and assess the risk, organization manage risk through the control objective and control, and organization should prepare the statement of applicability here. For the act here, in reference to the act here, that the organization should implement the identified improvement in the ISMS, that take appropriate corrective and preventive actions, that maintain the communication skill with all stakeholders and validate improvement as well. Now for the check here, and that for the check, the organization should perform monitoring procedures, that to conduct periodic reviews of the ISMS for that effectiveness, review level of acceptable and the residual risk, and conduct internal ISMS audits at the planned intervals here. And for the do here, that is implement as an operate ISMS, that the organization should formulate and implement a risk mitigations plan, and implements the control selected to meet the control objectives as well. Let's with regard of it, when we are talking about, now we'll discuss some of the detail here, and that is related to the main objectives and the scope of the IT Act 2000 here. In regard of it, if I'm talking about that, the objective, the main objective and the scope of the IT Act 2000, that is to grant a legal recognition for the transactions carried out by the means of the electronic data interchange and the other means of the electronic communication, commonly referred to as an electronic commerce, and in place of paper-based methods of the communication, to give the legal recognition to the digital signature for the authentications of any information on the matter to require the authentication under any law, to facilitate electronic filling of documents with government department, to facilitate electronic storage of data, to facilitate and give the legal sanctions to the electronic funds transfer between the banks and the financial institution, to give the legal recognition for the keeping of books and the accounts of by banker in the electronic form, and to amend the Indian Penal Code and the Indian Evidence Act, that is 1872, the Bankers Book Evidence Act 1891, and the Reserve Bank of India Act 1934 here. Now the scope of the IT Act here, and that is every electronic information is under the scope of IT Act 2000, but following electronic sanctions is not under the IT Act 2000 here. That is, the first is that Information Technology Act 2000 is not applicable on the attestations for the creating the trust via electronic way, like physical attestations is must. The second is that the IT Act 2000 is not applicable on the attestations for making a will of anybody, physical attestation by the two witnesses must. The third is that a contract of a sale of any immovable property. The fourth is that the attestations for the giving power of that is attorney of property is not be possible via electronic record as well. Now we'll discuss about some of the detail here, that is about the intellectual property. In the intellectual property here, and we'll discuss about the intellectual property as well as the importance of intellectual property here. And the intellectual property is a property that arises from the human intellect, and it is the product of the human creations as well, and it is an intangible form of property. It is a personal property, it is basic form of a property, and it is based on information as well. In the reference to the intellectual property, if I'm talking about here in a detail, and that will goes in reference towards it, and that what it is important of course. And in regard of it, the objects of the intellectual property here, that the object of the right that covered by the concept of intellectual property and manifestation of the human creativity, that the form of the work, the inventions, and the relationship between the symbol and the business as well. Now we'll discuss about the importance of protections intellectual property, that importance of protection of intellectual property, that what we have to discuss, where we have to discuss that protect investments in time, money, and other resource used to create new contributions to technology in commerce and entertainment. Here in the terms of it, if I'm talking about the objectives of intellectual property, as I told you about it, and we had discussed about the importance of protections of intellectual property, which is that protect investment in the time and money and other resources used to create new contributions of technology, commerce, and entertainment. And the government encourages the creator to disclose their creation to the public in order to promote the progress of science and useful arts, which are the engines of the development. Investors demand this guarantee, and that is the fosters economic growth and provides the incentive for the technological innovations, and that attracts investment that will create new jobs and opportunities as well. Now we'll discuss about what are the common mistakes firms make in the regard of the protecting their intellectual property, what they are making a common mistakes here, that is that are not properly identifying all of their intellectual property and not fully recognize the value of their intellectual property, not legally protecting the intellectual property that needs protecting, and not using their intellectual property as a part of their overall plan for success as well. Now we'll discuss about that the four major forms of intellectual property, and where what the four major forms of intellectual property that we have is, the first is the patents, trademark, copyright, and trade secret here. In regard of it, we'll go ahead with in detail in all here, and that is the first we have is your patent. So here we'll go ahead with the detail of patents here, and that is the four major forms of intellectual property. In the patents here, that is that anyone who invents or discovers any new and useful process, machines, and articles of manufacture or the compositions of matter, or any new and useful improvement thereof, and may obtain a patent as well. Now a patent as well. And now we'll go ahead with a trademark here, and that is the second major forms of intellectual property. In the trademark, a trademark is any word, name, symbol, or devices, or any combinations thereof used by a person, or which a person has bona fide intentions to use in the commerce, to identify or distinguish his or her goods from those manufactured or sold by the others, and to indicate the source of the goods as well. The third we have is your copyright here. In the reference to the copyright law protects the original works of authority fixed in any tangible medium of expression, that is the literacy works, musical, dramatic, and the choreographic works, pictorial, graphic, and sculptural works, and which is that is audio visual works and sound recording, architectural work, and the compilations and the collective work as well. The next we have is your trade secret, and in the reference of the trade secrets, a trade secret is a formula, patent, device, that technique, process, and the compilations of information that, and in the terms of it, is the subject of the reasonable effort to maintain the secrecy, and which derives economic value from not being generally known or rarely that ascertainable by others. And the trade secrets are protected by and by keeping the relevant informative secret as well. Now we'll discuss about the term patent in detail also, and explain to the patent law. That's why in the terms of the patents here in the terms of patent, a patent is a grant from of the federal government that conferring the rights to the exclude others from making selling or using an inventions for that is that is for the term of the patent. And the patent describes an inventions for which the inventors claims the exclusive right, and as the result it is inventors obtain that the patent for a new kind of the computer chip, and the chip would infringe on the prior patent and owned by the Intel as well. The inventor has no right to make the use or sell the chip as well, and to do so, with regard of it, to do so, the inventors would need to obtain the permissions from Intel, and Intel may refuse permissions or ask that licensing fee be paid for the right to infringe on its patent. And while the system may seem odd, and it is really the only way the system could work, and many inventions are improvement or existing the inventions, and the systems allows the improvement to be that is the patented and sold as well. And but we say that we can just say that in the reference towards it, that only with the permissions of the original inventors, who usually benefit and obtaining the licensing income in exchange for their consent as well. A patent for an invention, so with regard of it, we can say that in the terms of it, and in the terms of it, the patents right and are related to only with the permissions of the original inventors, who usually benefit by obtaining the licensing income in the exchange of their consent here. And a patent for an invention is the grant of the property right to the inventor issued by the United States Patent and the Trademark Office as well. In this, the utility patents are granted to everyone who invents or discovers any new and useful processes like machines, articles of manufacture, or the compositions of matter, or any new and the useful improvement thereof. And there are also design patents and the plant patents as well. And with regard of it, that the inventions is a new solution to the technical problem, that is a product, process, and the new use as well. It must be new, have an incentive inventive step, and be industrially applicable as well. In the regard of it, the policy that is rationale for the patent law, and that what we have is that the utilization theories, and that is the utilitarian theory, and that is maximum social welfare, creating limited monopoly right to incent inventions and disclose them to the public after a period of time as well. Now we discussed about list of the patentable subject matters and unpatentable subjects matter as well that we have here. In terms of the patentable subject matters here, and that we have is your human necessity, and the second is the performing the operations and transporting, and the fixed constructions, as well as that is your physics here. In the case of the human necessities here, that is agriculture, food, stuff, tobacco, personal or the domestic articles, health and amusements as well. And in the regard of the performing, that is operations and transporting, that is the separating, mixing, shaping, and printing and transporting as well. Chemistry and metallurgy, and as well as the textiles and the paper as well. For the fixed constructions, the building, art, moving, and mining, that mechanical engineering, that lightning, heating, weapons, blasting, including engines or pumps, and engineering in general. This is the physics here, that is the instruments, and that is nucleonics and electricity as well. Now with regard of the unpatentable subjects matter, that what we'll discuss in detail here, that a discovery, scientific theory of the or mathematical method, a literacy, a dramatic music, or the artistic work, or any other that is the or that is related to the aesthetic creations here. and a scheme, a rule, or a method for performing any mental act like playing a game or doing a business or a program for a computer, and mere presentations of information as well, and the plant varieties but not parts thereof, or product, or you can say that the biotechnological process as well. Inventions contrary, if I'm talking about the invention contrary to public order, that the morality of the public health and the safety principles of the humanity, and environmental conservations as well, and any other inventions that may be declared non-patentable by the ministers in charge of the industrial property matters. That in the reference to that, I will discuss about what are the rights of the patent holder and how long do the patent rights last. In this, that the patent status does not statute does not grant the right to make, use, offer to, for sale, sell the inventions in the United States, or imports the inventions into the United States, but the right to exclude other from the making, the using, offering, and so the sales, selling, or importing the inventions as well. In regard of it, that how long do the patent right last, and generally 20 years from the date of which the application for the patent was filled in the United States, or in the special case from the date of the earlier related application was filled, subject to the payment of the maintenance fees as well. What do you think to mark your inventions to get the patent protections here? In regard of it, that what you have to understood is that if you are selling a patented product, you should mark each item with the word patent or the abbreviation of pat dot, and that is together with the application patent numbers, example like patent number 1, 2, 3, 4, 5, 6, 7 as well. And if you fail to mark patented product, you cannot recover the damages for any patent infringements that occurs before the infringement has been actually noticed, or the patent of the patent as well. In regard of it, the patent, in the case of the patent, what we have discussed here, and with regard of it, you have to understood about the basic requirement for the obtaining a patent here, and there are the three basic requirements for the obtaining the patent, and that is the subject of the patent application, whether it is and the inventions, design, and the business method must be. The first is a useful, that is it must have utility. The second is the novel, and that is it must be different from what has come before, that is not in the prior art. And the third is they are not obvious, and that it must be not obvious to a person or ordinary skills in the field as well. Now we'll discuss about the types of patent with their durations here. The types of patents here, that is the types of inventions that is covered, and the duration as well. Now with related to the utility here, in the utility, that never a useful process, machine, manufacture, or compositions of material, or any new and a useful improvement thereof, this comes under the types of invention covered. And the duration is that the 20 years from the date of the original application, as I told you before also. In the terms of the design here, the inventions of new and original and ornamental design for the manufactured product, and with related to the duration, the 14 years from the date of the original application as well. The third we have is a plant here, and that is any new varieties of a plant that can be reproduced sexually, and that is the duration we have is the 20 years from the date of the original application as well. Now we'll discuss about some of the business method patent. Now we'll discuss about the business, that a business method patent, that a business method patent is a patent that protects an invention, that is, or the facilities or a method of doing business. The most notable business method patents they have been awarded, like Amazon.com's one-click ordering, and then Priceline.com's, that is the name your price and business model, on Netflix methods for allowing the customers to set up the rentals list of the movies to be mailed to them as well. In the terms of it, that obtaining a patent, and also the term of the patent infringement, you have to be very clear about it, because the step one is to make sure that the invention is practical. The step two is to the documents when the invention was made, and the third is that hire a patent attorney, and the fourth is that the conduct a patent search, fifth is that the file a patent application, and the sixth is to obtain the decisions from the US Patent and the Trademark Office as well. These were the six steps when the process of the obtaining a patent has been following. And now we'll talk about the patent infringement here. and that in the patent infringement that takes place when one party engages into the unauthorized use of the another party patent. And the tough part is, particularly from a small entrepreneur firm a point of view, is that the patent infringement cases are costly to litigate here, and a typical patent infringement case cost each side at least $500,000 to litigate here. Now we'll talk about the term trademark with the policy relation reliable to the trademark law as well. As you can see here, in the terms of the trademark here, that the trademark is in any word, name, or a symbol or a device used to identify the source or origin of the product or services, and to distinguish those product or the services from the others as well. It is not mandatory to mark your goods with the R or to be get or trademark protections, or in fact you can use the R once the mark has been registered, not even while it is pending as well. The policies that is rationable for the trademark law, that is, the first is that prevent consumer confusions and reduce the consumer search cost. The second is to encourage the trademark owners to maintain quality. The third is to prevent free riding on the goodwills as well. The examples of trademark is the Ford sports appraisal, and that is the Nike. You can do understood that the examples of the multicasted nature of the trademark protections that we have. And with regard of it, the process of obtaining the trademark, that also explain the right to the trademark owner. That the process of obtaining a trademark, the right to the trademark owner, we can say that here that the right of the trademark owner that prevent the trademark infringement, use of the mark in the commerce where use it likely to cause the confusion or the deceives, prevent the trademark dilutions, that is use of the mark in the disparaging way, that the tarnishment or the overuse of marks, that is blurring. Step 1 is to select an appropriate mark. Second is that to perform a trademark search, and the third is to create create rights in the trademark. Now we'll discuss about the types of trademark. Here is a categorization of types of trademark, types of the mark coverage, and the duration as well. In regard of it, we'll discuss more in detail, and that we have here. As you can see, the first is your trademark here. In the trademark, that any word, name, and a symbol device used to identify and distinguish the company's goods from the another, and that comes under the types of mark covered. And the examples for this we have is your that is Dell, Nokia, Oracle, Polapa, Azul, and Flavorex here. And the duration for this is that the renewable every 10 years as long as the mark remains in the use here. For the service mark here, that is the type of a mark covered is that is similar to the trademark, are used to identify the services or the intangible activities of the business rather than the business physical products. Example is that Amazon.com, Orbit's, eBay, and Overstock.com, and the Pandora's as well. And that in the durations here, that renewable every 10 years as long as the mark remains in use here. Now we'll go ahead with the detail, and the another one and that we have here is in the terms of it, that what we have to discuss as well. And in the regard of it, that is the third one, that is we have is your collective mark, and the rest is the certification mark as well. Here in the collection, that is collection mark, that it states for that the trademarks are the services mark used by the members of the cooperative associations and other collective groups. And the examples we have is that the Rotary International franchisees and associations. In the terms of the duration, that is the renewable every 10 years as long as the mark remains in use. The certification mark, that is the marks, words, and name or symbols or the devices used for a person other than its owner, and to certify a particular quality about a goods or services. The example we have is that the Florida oranges, ISO 9000, under Writers Laboratories as well. And the duration we have is the renewable every 10 years as long as the mark remains in use as well. Now we'll go ahead with the copyright, and before going through with the copyright here, we'll have to understood that what is protected or what is not protected by the trademark law as well. And regard of it, that we'll have to understood about the inclusions here. Inclusion for the trademark protection, that we have is the words, numbers, and the letters, designs, and the logos, and the sounds and the fragrances, shades, colors, trade dress. Exclusion from the trademark protection, that is immoral and the scandalous matter, and the deceptive manner. If I'm talking about the deceptive matter, for example, a food company could not register the name, that is a fresh Florida oranges, if the oranges were not from Florida. And the descriptive matter, that marks that the merely descriptive of the product or the service cannot be trademarked. And for example, if you developed a new type of a golf ball, and you cannot get a trademark on that, the word a golf ball. And the surnames, yes, a trademark consisting of the primarily of the surnames such as the Anderson, John Smith is typically not protectable here. And the additional feature about the trademark here, that is the duration. Once a trademark has been used in the interstate commerce, it can be registered with the US Patents and the Trademark Office for the renewable term for the 10 years, and that can theoretically can be registered for over as long as the trademark stays in use. And the registering the trademark, that is technically a trademark does not need to be registered to receive protections. When it is used, it is protected. And there are many advantages, however, to registering a trademark with the US Patents and the Trademarks Offices as well. Now, with the rate must a trademark right to register to obtain the trademark protection? So yes, no, but federal registration has several advantages, like that is including the constructive notice nationwide of the trademark owner's claim and evidence of the ownership of the trade as well. And the jurisdictions of the federal courts may be invoked, and the registration can be used on the basis of the obtaining the registering in foreign countries, even though the registration may be filled with US customs services to prevent importance of the infringing foreign goods as well. Now we'll discuss about the copyright. As you can see here in the terms of the copyright here, and that what it stands for is a copyright is a form of intellectual property protection that grants to the owner of the work of authorship and the legal rights to determine how the work is used to obtain the economic benefits from the works. And with regard of it, the work does not have to be artistic merit to the eligible for copyright protection, and as a result, things such as operating manuals and the sale of brochures are eligible for the copyright protection as well. In regard of it, that for the reference to the copywriter, it is not mandatory to be registered to obtain the protection, but you must register to sue for the infringement, and it is not mandatory to mark your work with a C to get the copyright protection, but it is generally a good idea. And in regard of it, that the policy that is rationals for the copyright law, that is that utilitarian theories, personal that is autonomy theories, and the labor desert theory here. The utilitarian theory that maximize the social welfare, create limited monopoly rights to the incentive creative works. And in the personal autonomy theories, that we have is the grand author control over the creations. And the labor desert theory, that is grant property rights in the work created by the labor of individual as well. Now we'll talk about that what are the rights of the copyright owner and how long do the copyright last here. In regard of it, that what we'll discuss here is in the right of the production of adaptations, distribution, public performances, public display, public performances of the sounds recording by the digital audio transmission, that is 17 USC, and that is $106A. And the modal rights for the certain work of visual art, that is 17 USC, and then 106A. And new anti-circumventions and the anti-trafficking rights in the DMCA, 17 USC, and $1201. And new protections of the copyright management information in a DCMA, that is 17 USC, and that is 1202 as well. The defenses, the exemptions of a compulsory license. In the case of that, the durations of copyright rights is that is the basics copyright terms for the works created or after the January 1st, 1978 is the life of the author plus 70 years. And with regard of it, it works in a created for a hire of the copyright owned and by the corporate entity, otherwise than by the transfer. Then 5 years from the publications, of 120 years or from the creations which is expires first here. And what is expected or what is not protected by the protected, and what is not protected in the copyright law here. In regard of it, if I'm talking about the inclusion for copyright law, is in the terms that the inclusions for the copyright law, like literacy work, computer software, that is panoramics, and that is choreographic works, musician composition, and dramatic works, pictorial graphics, and the sculptural works as well. Exclusions from the copyright protection is that the idea expresses dichotomy, that is the main conclusion is that the copyright law cannot protect ideas. For example, an entrepreneurship may have the idea to open the sauces themed restaurant, and the idea itself is not eligible for the copyright protection. However, if the entrepreneur writes down the specifically what is on her sauces themed restaurant, will look like, how it will operate, and then description is copyrightable. And the legal principles describing this concept is called the idea expressions dichotomy. An idea is not copyrightable, and but the specific expression of an idea is, of course. In the regard of it, that what process of obtaining a copyright, and also define the copyright infringement. As I told you about the infringements as well, that the copyright law protects any work from the authorships and the moment that assumes the tangible form, and that technically it is not necessary to provide a copyright notice or registers work with the US Copyright Office as well. And in the following steps that can be taken, however, to enhance the copyright protection, like copyright protection can be enhanced by attaching the copyright notice or the copyright bug or to something, or further protection can be obtained by the registering the work with the US Copyright Office as well. In the copyright infringement, the copyright infringement occurs one work derives from the another of its that an exact copy or the shows a substantial similarly in the original work as well. And to prove infringements, a copyright owner is to require to show that the alleged infringer had a prior access to the copyrighted work, and that the work is substantially similar to the owners as well. In the copyright infringement that cost the owners of the copywritten material and the estimated $20 billion per year. What the next question that has been arise, that what do you mean by the trade secret, or the define the areas in which the trade secret protections is must. In the trade secret, if I'm talking about here, and that the trade secret is any so here in the case of the trade, a secret is any formula that is pattern of physical devices, ideas, process, and the other information that provides the owner of the information and with the competitive advantages in the marketplace as well. And that trade secrets include the marketing plan, product formulate, and the financial forecast as well, and that employee rosters, logs to of sales call, and the similar types of the that is proprietorships information as well. And the Federal Economic Espionage Act that is passed in the 1996, that is the criminalizes the theft of the trade secret as well. And now we'll talk about the areas in which the trade secrets protection is must, and that is we have in the reference to not all the information qualifies for the trade secret protection, but in general the information that is known to the public or that a competitor can discover, though through legal means, does not qualify for the trade secret protection. And the stronger case for the trade secret protection is the information that is characterized by the following, and that we have is that is not known outside the company and is known inside the company, or the need to know basics only, and the safeguarded is safeguarded by the stringent efforts to keep the information secret, and is valuable and provides the company and the competitive edges as well, and was developed at a great cost and time and effort as well. In the regard of it, that what are the physical measures for protecting the trade secrets here? The first is that to restricting the access to the confidential matter. The second is to labeling the document a property and restrictive or secret. The third is to password protecting the confidential computer files. The next is to maintaining the logbooks for the that is visitors, and the next is to maintaining the logbooks for access to the sensitive material. The next is maintaining the adequate overall securely measures as well. Now to provide an overview of the intellectual property related legitimations is in India. In regard of it, the Trade and the Merchandise Mark Act 1958, that is TM Act 1958, has been replaced by the Trademark Act 1999, and the Copyright Act 1957 has been amended to protect the computer program as literacy work. This question has been asked in many times in the in your examination paper, that is to provide an overview of the intellectual property related to the legislations in India. So that what we have deal with here. So you can just write it down. All these are important and plays an important role as well for your examination. The Patent Law 1917 has been amended by the Amendment Act in 1999 and 2002 and 2005. The Design Act of the 1911 has been completely replaced by the Designs Act 2000, and the following laws has been enacted to protect the newly recognized species of intellectual property in India, and that we have is the Geographical Indications of Goods, Registrations and Protections Act 1999, the Semiconductors Integrated Circuit Layout Design Act 2000, and the Protections of Plants and the Varieties of the Farmers' Right Act 2001, and the Biological Diversity Act 2002. That the nodal agencies and the IPR facilities in India is TIFAC, that is a Patent Facilitation Cell, that is www.indiapatents.org.in, that is a website here. CII, that is the Andhra Pradesh Technology Development and Promotion Centers, that is www.aptdc.com/www.aplpr.org. you can just write it down. The next is the National Research Development Corporation, that is www.nrdciindia.com. And the next is write a short note in the intellectual property audit. As I told you many times here, in the regard of intellectual property audit, that you have to be gone in detail, because they had asked you many times and in reference to the questions here. So here the first step to take you should protect the intellectual properties to complete an intellectual property audit. An intellectual property audit is conducted to determine the intellectual property a firm owns, and there are the two reasons for conducting an intellectual property audit. That is, the first, it is a prudent for a company to periodically determine whether the intellectual property is being properly protected, or second, it is important for a firm to remain prepared to justify its valuations and events in the merger or acquisition. The process of conducting the intellectual property audit, that what we have is, the first step is to develop the inventory of the firm's existing the intellectual property. The inventory should include the firm's present registrations of patent and trademark and the copyright as well. And the second step is to identify the work in the progress to ensure that they are being documented and protected in the systematic and orderly manner as well. In regard of it, now we'll go ahead with the license here. Types of licensing agreement existing. Before that, we have to understood about that what is license here. Then we'll discuss about the types of here. And the first is in regard of it, that is the types of license. The licensing is that grants the permission to use a copyrighted work, can grant any or all the rights associated with the copyright, and as well as can impose other restrictions such as the type of or place or the usage or the durations of the license, or does not transfer ownership of the copyright. Now we'll discuss about the software licensing agreement. In the software licensing agreement, a software licensing agreement is a legal contract between a software buyer, that is user, and the software manufacturer, that is or manufacturer's reseller. That broadly licensing agreement consists of the three parts. That is, the first part is that the master agreement. The second is the end user license agreement, that is, we can say that it is EULA. The third is the product software product here. In the terms of the first one, the master agreement here, in this, that explains the conditions of sale, and generally it explains the cost of the acquiring the license agreement, the software being licensed, and who can use the software and what purpose the software can be used, and the conditions of this maintenance contract, and the tech support services, and how the software can be installed and accessed by the user as well. For the second one, that is the end user license agreement, that is EULA here, that explains the specific rules and the restrictions governing the use of the product being licensed, such as the classifications of illegal usage and the terminations of the user right to use the software, and conditions of the redistribution of the software rules, and the restrictions governing how the software can be incorporated into the another product, and the disclaimers of the warranties as well. The third, we have the software product here, and it is also being implicit conditions of use and the performance capabilities and the expectation that is the software can perform under the every circumstances, and the condition that should not be certainty. And for example, the Windows applications and the Microsoft Offices, that Microsoft Access may not work with every product that can emulate and the Windows operating system, such as the Linux, VMware, and of course the Windows 4L here. In regard of it, we can say that for also the manufacturer that cannot be guarantee that their software can work with all of the other software application on the computer system. For example, it is not recommended that So in the case of the software the software applications on the computer system, for example, it is not recommended that you run the virus protection application such as the systematic not an antivirus and the network that is associates and virus scan on the same computer system. If it is so, then these two programs can clash and slow down the computer as well. So here we'll end up with this, and the next coming class we will discuss the another one, and with after that we will be ending this class here only, because it will gone too long, and that it is not a matter at all. And the next coming class we will end up with the cyber security as well. And for that sake, what we have to do is to go through with the please like, share and subscribe our channel, so that many and maximum people can get the information at once, and even though you can also enjoy the video as well. Now we'll talk about the unit 1 as well as what we had discussed about it, and that what I had explained you in the classes here. In the unit 1, the introduction to the information system, that the types of information system, the development of information system, introduction to the information system, need of information system, security, threat of the information system, information assurance, cyber security, and the security risk analysis as well. In the unit 2, the application security, that is database, email and the internet, data security concentrations, backups, archival storage and the disposals of data security technologies, firewall and the VPNs, intrusions, detections, access control as well. And the security threat, that is in the second unit only, that the security threats, that the viruses, worms, trojan horse, and then bombs, trap holes, spoof and email viruses, microviruses, malicious software, network and the denial of the services attacks, security threats of the e-commerce, electronic payment system, e-cash, credit and debit cards, digital signature and the public key cryptology here. Then we had discussed about the developing the secure information system, application developing security, information security governance and the risk management, security architecture and the design as well. And the security issues in the hardware, data storage in the downloadable devices, the physical security of the IT assets, access control, CCTV, intrusions detection systems and the backup security measures as well. In the unit 4, we had discussed about the security policies, why policies should be developed, www.policies, email security policies, policies review process, corporate policies, sample security policies, publishing the notification requirement for the policies, information security standard, ISO, IT Act, Copyright Act, Patent Act, IPR, cyber laws in India, that what we had discussed about it, IT Act 2000 prevention, that we had discussed about it, intellectual property law, we had discussed about it, copyright law, that we had discussed about it, the software license, yes, we started from this, and we'll discuss in detail as well the types of the licensing agreement as well, that will go in detail in the next coming classes, and the semiconductor law and the patent law, that has been left, and then after that we'll end up with cyber security, and that is also plays an important role in the competition wise here. So first of all, it's a huge request कि अगर आप हमारे चैनल फर्स्ट टाइम देख रहे हो या अभी तक आपने हमारे चैनल को सब्सक्राइब नहीं किया है, please go through with the subscribe button so that many and maximum people can get the information at once, and even though you can also enjoy the video as well. Thank you, thanks for supporting us. Please like, share and subscribe to our channel. Thank you.